Hello, guys, and welcome to another episode of our civil litigation mock trial course by the DECO Daniel School of Law. And on today's episode, we are talking about the draft of interim injunction and interlocutory injunction. The draft of interim and interlocutory injunction. So there are two drafts, right? If you have gone through my class on interlocutory applications, right, I taught you that there are two types majorly, right? We have the motion on notice, we have the motion ex parte. Also, I taught you that when we are talking about injunction, there are different types of injunction, right? We have the interim injunction, we have the interlocutory injunction, we have Mareva injunction, we have Antompila injunction and others. Do you understand? Now, in this drafting class, when it comes to law school, more often than not, you are very likely to have a question on either interim injunction or interlocutory injunction. More often than not, you are going to be asked this question that you should draft an interim. Interim is when it is a matter of urgency, and for interim injunction, you use motion ex parte. When you are talking about interlocutory injunction, interlocutory injunction is done or is sought for when you want the court to make an order pending the determination of a suit. So an interlocutory injunction is sought for using a motion on notice. I think I've taught this already in my class on interlocutory applications, injunctions, and interpleader proceedings, right? I think that is module 8. Interlocutory applications, injunctions, and interpleader proceedings, right? So in this class now, we are talking about the drafts. We are talking about the draft. You might not necessarily understand what we are saying, except you have gone through the class. Do you understand? I think that for module 8, we have 30 classes where I talked about each of these things. I talked about interlocutory application, I talked about injunction, and I talked about interpleader proceedings in 30 classes for civil litigation. But in this class now, we are talking about the draft. You know, I told you that I will still teach you in the draft section about the draft for interlocutory injunction and interim injunction. So now, one thing that you need to know is that they are basically similar. They are very, very similar, but I will show you the little differences. Do you understand? So I will use the motion on notice, which is interlocutory injunction, to teach the both of them. Now, the first thing when you are drafting, right? When you are drafting, the first thing that we have to look at is what? We are looking at the heading of the court. Your heading of the court must be proper. I think I also taught that in my class on claims and statement of claim and all that, right? Please look at it very well. The heading of the court. In the High Court of Lagos State, in the Lagos Judicial Division, holding at Lagos. If it is Abuja, in the High Court of the Federal Capital Territory, in the Abuja Judicial Division, holding at Abuja. For the purpose of law school, the specific judicial division does not matter. There is nothing like in the Ekpe Judicial Division, in the Ikorodu Judicial Division, in the Surulere Judicial Division. There is nothing like that for the purpose of law school. In the High Court of Lagos State, in the Lagos Judicial Division, holding at Lagos. That is half mark. Suit number, you must put it there. If you don't put it there, you have lost half mark. That's another half mark. Now, the parties, right? The parties, you're going to have the claimant and the defendant. Now, you can have the claimant and the defendant, and then you can have the claimant being the applicant. If you do not put that, applicant and respondent for either the claimant or the defendant, you have lost a large chunk of mark. I think that is 1 mark for the parties clause, right? It's about 1 mark for the parties clause. So please make sure that you go through our parties class. You know in what capacity each person can sue. When we are talking about representative actions, how do you sue? When we are talking about unregistered association, how do you sue? When we are talking about business name, how do you sue? When we are talking about incorporated trustee, how do you sue? I already taught that in our module 3. right? When I taught parties to a civil action, right? We had about 20 classes or close to 30 on that as well. Please make sure you go through those classes and you learn them, so that when you are drafting this parties clause, you will properly know how to draft. So immediately after the heading of the court, we go to suit number. After suit number, we go to parties. Now, when you are now drafting the parties, when you are having a motion on notice or a motion ex parte, you must tell us who is the claimant, you must tell us who is the defendant. So in this case now, we have Turnbull Chikelu, who is now the claimant slash applicant. He is the one that is applying for this motion on notice. I have told you previously that an interlocutory application cannot stand on its own. It is dependent upon a suit. If not that the suit has been created, but there must be a contemplation of creating one. Do you understand that? If the suit has not been created yet, there must be that you are contemplating creating one. Do you get my point? So when we are talking about interlocutory application, you must tell us, based on the suit that has been created or that is about to be created, who is the claimant and who is the defendant, right? Once you have done that, then you will now tell us who is the claimant, who is the defendant. Now, who is applying for the motion on notice or the motion ex parte? That person is the applicant. The other person who is responding is the respondent. For any interlocutory application, motion on notice, motion ex parte, the person applying is the applicant, the person responding is the respondent. This thing comes out in MCQ. I have seen it in an MCQ receipt set. I have seen this particular question in an MCQ. Who is the applicant, who is the respondent? Right? Don't say it is a defendant in an application or an interlocutory application. The party that is responding is called the defendant, it's called the respondent. Now, after we have done that, we now take it a step further. The moment you see motion on notice, you know that this is an interlocutory injunction. When you see motion ex parte, you know that this is an interim injunction. I am speaking in the context of only these two injunctions. When you see an interlocutory injunction, then you know that it is motion on notice. When you see an interim injunction, you know that it is motion ex parte. So now that you can see glaringly, you can see motion on notice, you know that we want to draft what? An interlocutory injunction. Now, the next thing is brought pursuant to Order 42 Rule 1 and Order 43 Rule 1 of the High Court of Lagos State Civil Procedure Rules 2019 and under the inherent jurisdiction of this Honorable Court. Now, I have told you when I was teaching you the injunction class that when we are talking about the general order through which you make all applications, we are talking about Order 43. Order 43 is the general order through which you make all applications. So when you are drafting any interlocutory application, motion on notice or motion ex parte, you must have Order 43. Now, the specific order that made provision for interim injunction and interlocutory injunction is what? Is Order 42. So when we are talking about interlocutory applications, we are talking about Order 43. Every application that you are bringing before the court comes through Order 43. But because injunction has its own specific order, which is Order 42, we are then going to write it down. If you have not gone through my classes on motion on notice, motion ex parte, interlocutory application, injunction, and interpleader proceedings, everything I'm saying here might sound like Japanese to you. But if you have gone through this class indeed, right, this drafting class will be so easy because you will flow through it. So please, it is important that you actually go through those classes. So as I was saying, when you are drafting your interlocutory injunction or your interim injunction, you use the same order for the both of them. Order 42, which is the order for both interim and interlocutory injunction, and Order 43, which is the general order for all application. So you will say brought pursuant to Order 42 Rule 1 and Order 43 Rule 1 of the High Court of Lagos State Civil Procedure Rules and under the inherent jurisdiction of this court. In all applications, you must put an under the inherent jurisdiction of this court. Do you understand that? So there are three things here that you are bringing under your broad pursuant to when we are talking about interim injunction and interlocutory injunction. Number one is the order that talks about both interim injunction and interlocutory injunction. What order is that? Order 42. Number two is the order that talks about the general application. The order that you bring all applications under. What order is that? Order 43. And number three is now bringing it under the inherent jurisdiction of the court. So therefore, the three things brought pursuant to Order 42 Rule 1 and Order 43 Rule 1 of the High Court of Lagos State Civil Procedure Rules 2019 and under the inherent jurisdiction of these courts. Do you understand? If it's an interim injunction on the topic, the head, you are going to write motion ex parte if it's interim. But if it is interlocutory, you are going to write motion on notice. I hope you understand that. Now go to the body. When we are going to the body, we have the general talk, right? The general talk for all motion. Take notice. You see that take notice? Law school loves it a lot. Take notice that this honorable court will be moved on the dash day of dash 20 dash at the hour of 9 o'clock in the forenoon or so soon thereafter as counsel for the applicant or the claimant applicant may be heard praying this honorable court for the following relief. Now, the reason why I said claimant applicant is because in law school, that's what they want to see, right? I know this because I asked the lecturers. So you would not just say that so soon thereafter as counsel may be heard on behalf of the, no, as counsel may be heard on behalf of the claimant applicant and not just on behalf of the applicant. So if it's the defendant applicant, then as counsel may be heard on behalf of the defendant applicant. Or as counsel on behalf of the claimant applicant may be heard. It's still the same thing. You can say as counsel may be heard on behalf of the claimant applicant, praying this court for the following reliefs. Do you understand that? Or vice versa. The point is the cocoa is there. Counsel is being heard on behalf of who? Do you understand that? And what are you praying this court for? So to say it again, at some point you are going to start singing it. Take notice. I'm not reading the note. It's already in my head. I can draft it from my head because law school already taught me. Do you understand? There is no way you will not know this. Take notice that this honorable court will be moved on the dash day of dash 20 dash as counsel for the claimant applicant may be heard praying this honorable court for the following reliefs. Now note that I missed one thing, which is another thing that people miss, right? I missed the time. So immediately after you say on the dash day of dash 20 dash, you must say the time. So take notice that this honorable court will be moved. First thing, when? On the dash day of dash 20 dash. As at what time? At the hour of 9 o'clock. Always 9 o'clock, even though our courts do not sit at 9 o'clock. If you go for externship, you will know. They don't sit by judge. Where there are some judges that are quite hardworking. But some other judges that I know, it doesn't even know if they will sit at all. So at the hour of what time? 9 o'clock, right? Or so soon thereafter. Immediately after at the hour of 9 o'clock, you must write so soon thereafter. So let's take it again. Take notice that this honorable court will be moved on the dash day of dash 20 dash, right? Immediately after that is what? At the hour of 9 o'clock. At the hour of 9 o'clock. Or so soon thereafter. Why? As counsel may be heard on behalf of the claimant applicant praying this court for the following relief, or as counsel may be heard praying this court on behalf of the claimant applicant for the following reliefs. All of them are the same thing. You are saying the same thing, you just shifted the location. Do you understand? So we then go to the next thing. What's the next thing? This is the thing that makes this particular application an interim injunction or an interlocutory injunction. So you can see, I put the order closely together for a reason, because I want to show you, if you were to draft an interlocutory injunction like this one is, the first thing that you will put is the motion on notice on the top. And then what you are drafting is an order of interlocutory injunction restraining the defendant respondent. Not just restraining the respondent, not just restraining the defendant, restraining the defendant respondent, whether by himself or through his agent, privies, or assignees, from building on the land or trespassing on the land or any other thing that you want to restrain the defendant from doing, you say it there. So there are three things. Number one, an order. Put your order in capital letter. My drafting style, my order is usually in capital letter. Yours can be in small letter. So mine is usually in capital letter. Now, an order of interlocutory injunction restraining the defendant, respondent, right, whether by himself or through his agent, privies, or assignee from building on the land or trespassing on the land or any other thing that you want to add, lying and situate at number 5 so street. Now, another thing that distinguishes pending the determination of the substantive suit. When it's an order for interlocutory application, we are making it pending the determination of the substantive suit. Now, look at that of an interim injunction. An order of interim injunction restraining the defendant respondent, whether by himself. Please, what's the difference? The first one is an order of interlocutory injunction. This one is an order of interim injunction. That's the only difference. Because in the both of them, we are still restraining the defendant, whether by himself or through his agents, privies, or assignee from building on the land or trespassing on the land, lying and situate at number. It is still the same thing that you draft. The only difference there is that the first one is an order of interlocutory. If we are drafting an interlocutory injunction, which is motion or notice, we say an order of interlocutory injunction restraining the defendant, blah, blah, blah. Then at the end, we now add pending the determination of the suit. You can see that I underlined it and I emboldened it because that is what distinguishes interlocutory injunction from interim injunction. Now, when you are now drafting an interim injunction, you will now say pending the determination of the motion or notice for interlocutory application. You will now say pending the determination of the motion or notice for interlocutory injunction. When I was teaching you our classes on interlocutory application, I can remember telling you that no court will grant an ex parte motion for interim injunction if you have not shown that you have filed your interlocutory injunction motion or notice. And no court will grant an extension if you have not shown that you have served your motion or notice. Do you see that? And that is the reason why what you couch in your order for interim injunction ex parte is pending the determination of the motion or notice for interlocutory injunction. So you can see what is our first difference here. The heading was the first difference. The heading. What is the heading saying? Motion ex parte if it's interim injunction, but motion on notice if it's interlocutory injunction. That's the first thing. The second thing, which is the basic difference, is the order that you write, an order for interlocutory injunction. But if it's interim, an order for interim injunction. All those things in the middle, they are all the same for both interim injunction and interlocutory. Then towards the end, you will now say pending the determination of the substantive suit if it's interlocutory injunction. But if it's interim injunction, you say pending the determination of the motion on notice for interlocutory injunction. Can you see the substantive difference between the both of them? So one thing that you need to couch very well, learn how to couch. You are restraining the defendant respondent. This part, whether by himself or through his agents, privies, or assignee, from doing what? You are asking the court for an order, stopping the defendant, restraining the defendant. I don't want to go into our class on where you use the both of them. There's already a class on that. This is the drafting class. Do you understand? We are restraining the defendant. Restraining the defendant from doing what? From, going on the land, right? Either by himself or through his agent, privies, or assignee, from building, trespassing, or whatever it is that you want to restrain. Then you now tell us where the land is situated. Lying and situate at so place. Are you seeing what I'm talking about? Please learn this part very well. An order of interlocutory injunction restraining the defendant respondent, whether by himself or through his privies, that's acting through his privies, his allies, or whatever it is, from building on the land, trespassing on the land. But which land? Lying and situate at number so, 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 and so. Pending when? Pending the determination of the motion on notice for interlocutory injunction if it's an interim injunction you are seeking for ex parte. Do you understand that? So now, lastly, we then talk about the general order. So please, you don't put these two things in your draft. I am only showing you, so you use them in the alternative. Right? If it is interim injunction you are drafting, use interim. If it is interlocutory injunction you are drafting, use the one for interlocutory. Don't go and say that you saw it in Mr. Dieko's drafting class on YouTube or something where you say you saw that I put the both of them there. I am only using it to teach. Because some students, I used to wonder. Now, secondly, you now ask for what is known as the omnibus order. The omnibus order is when you are saying, and for such further orders or others. You just say, and for such further orders, that's all right. And for such further order or others, as the honorable court may deem fit to make in the circumstance. And for such further orders, as the honorable court may deem fit to make in the circumstance. It is known as the omnibus prayer, where the court can also give you other orders that are contingent, right, upon this order that you are asking for. If it's such that this order that you're asking for will not be able to be carried out because certain other things are stopping it, the court can make, certain orders, in relation to those things that are stopping it, so that it's order. That's the other one that you're asking for. An order for either interlocutory injunction or interim injunction can be carried out, right? I already explained this once again in our substantive class, where I talked about interlocutory application, injunction, and interpleader proceeding. Now, to round up this class, in every application, please, after your omnibus prayer, use your dated this dash day of dash 20 dash. Very important. Write your date. And then you will see the part for the counsel, which is at the right-hand side of your draft. Your name, your office, who you are representing, your address, your email, and your phone number. Very important. Your name first, then your office. Dear Cole Daniels Esquires or Dear Corolla Daniels Esquire from Dear Cole Daniels and Partner, right? Then who am I representing? I am representing the claimant. Therefore, I'm the claimant counsel. Where is my office address? My office address is so, 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 and so. What is my phone number? What is my email? It is important. You do the same thing. You are on notice. Now, another thing. If it's an interim injunction, which is ex parte, there is no unnoticed to, because ex parte is held by just one person. So you see, this unnoticed two parts is only for interlocutory injunction. I don't want to have two different classes where I will teach substantially the same thing. That's why I'm teaching it together here and I'm differentiating it for you. If it is ex parte, which is an interim injunction, you are not supposed to put on notice. It is when it is motion on notice that you put on notice to the respondent counsel. You now write the name of the respondent counsel, the office of the respondent counsel, the address of the respondent counsel, the email, and the phone number. Do you understand that? So with this, I believe that we are done with our class on the draft of interim injunction and also the draft for the interlocutory injunction, and I hope that you enjoy this draft class. We have other draft class to work on, so let's get straight to our other classes. Please make sure you have a very wonderful day.